USA versus Kramer. A father was prosecuted under the Federal Child Support Recovery Act, CSRA, for failure to pay child support. Underlying state support order had been entered by default without personal jurisdiction over the father. What happened? Kramer was criminally prosecuted for failing to pay child support under the federal CSRA. He argued that the underlying state child support order was void because the state never had personal jurisdiction over him. He was never properly served. The government argued he couldn't challenge the state order in federal criminal court. So, legal question. Can a defendant in a federal child support prosecution challenge the underlying state order as void for lack of personal jurisdiction? Outcome. The 7th Circuit Court held that the default child support order entered without personal jurisdiction is void and can be collaterally attacked, even in a federal criminal prosecution. The court said this long-going standing rule, both in federal and state jurisprudence, a default judgment without personal jurisdiction is a nullity. They have to serve you properly. You have to have an opportunity to come to court and be heard, okay? Federal appeal court said default orders without personal jurisdiction are void, can be attacked collaterally, even years later, even in criminal court. This is a long-standing rule, not a new theory. This ain't new, y'all. This is way back in 2000, okay? UIFSA requires jurisdiction for recognition. No jurisdiction means no valid order. This applies to default orders where you were never properly served. Kramer is a 7th Circuit case, federal appeals court, all right? A father was criminally prosecuted for not paying child support. He said the underlying order was void because I was never served. The court agreed. A default order without personal jurisdiction is a nullity, okay? And it can be attacked at any time. This is not my opinion. This is the Federal Court of Appeals, okay, family?